What sort of medication would be considered grounds to suspect someone of a DUI? Attorney Brian Sloan says, any type of impairing medication could be considered for a DUI. There are probably about 1,000 different types of chemical compounds, medications, and drugs listed in the Arizona law books that can be used to charge someone with a DUI, although the medicine would need to be impairing. Some sort of chemical composition would need to show up in the test that was either on that list or was otherwise generally impairing. Taking an Advil would not be considered impairing, which is why it would not be on the list of illegal substances. Nowadays, there are a lot of incidences of distracted driving because of people fiddling with the radio, fiddling with their GPS, or looking at their cell phone. I have had many clients claim they just dropped their cell phone, or they dropped a drink or something else, which is why they were driving the way they were, and that was most likely why they drove outside of their lane or slightly drove into a bicycle lane. Officers use that kind of driving behavior as an excuse to pull someone over because they were swerving or driving in a bike lane, despite the simple explanation as for why the person pulled outside of their lane or drove abnormally. This would be an excuse for officers to talk to the person, and it would all of a sudden turn into a DUI if the officer suspected alcohol, drug, or medication impairment. I handled a case recently where we used something that I call the Skittles defense. My client was driving with a combination of medication in her system that she had been taking for a decade or more. The officer was following behind her, and she was driving all over the roadway, but she was driving perfectly fine when the officer put on the lights and turned on the siren. She was able to pull over, but they wanted her to be convicted of a DUI based on the prescription medication she had been taking for years. I argued to the jury that the client was driving poorly because she dropped her Skittles in the car, and the Skittles went all over the floorboard, so she was picking them up, and that was why her driving was affected. And we knew she was not impaired by her medications because she was driving perfectly fine the moment the emergency lights and the siren went on, because she stopped searching for and trying to grab for her Skittles. There were a lot of other indications of possible impairment in that case, but I recall she was drooling quite a bit. But ultimately, I was able to explain to the jury that she was not someone who was impaired, and she simply made a mistake in trying to gather up her candy, and upon the officer indicating he was behind her and that he was going to pull her over, she drove perfectly fine because it had nothing to do with impairment by her medications. So the jury agreed and found her completely not guilty. For a free phone consultation, contact attorney Brian Sloan in Phoenix, Arizona, at 602-357-8980, or visit him on the web at www.arisdui.com.